Mr. King.
Chair Pierce, members of the board, my name is Roger King. I appear here today on behalf of the HR Policy Association, the leading HR spokesperson for large companies in this country from the Chief Human Resource Officer perspective. I also have the pleasure of appearing here this morning, or this afternoon, excuse me, on behalf of the Society for Human Resource Management. I have with me Nancy Hammer and Kelly Hastings. They're in the audience. Mr. Chairman, I think I would be less than candid if I said it's a pleasure for many of us to be here today. We are going back through what we thought was resolved in 2011 and thereafter. But we are here, and we do appreciate the opportunity to share views and comments. I think I've been involved in each of the board's rulemaking initiatives over the years, including the healthcare rulemaking initiative. And I will say I commend the board for the process you are applying today by going by topic. I think that's certainly an improvement over what we experienced in 2011. But, Mr. Chairman, not at the standard that we had with respect to the healthcare amendments. I know you're going to hear later about that tomorrow from my partner, Kurt Kirschner. I want to stress at the outset a concern that many of us have. The board clearly has the right to engage in rulemaking. No question about it. The statute clearly permits that. But I believe that's a very, very serious burden for this board to carry, and they need to do so very thoughtfully and very carefully. You are dealing with delicate balances that have been established over the years between labor, management, and employees. That's particularly the case here. What's being proposed has many different ramifications throughout the board's rules and regulations. Those have been carefully crafted over decades. They've had involvement of very experienced labor lawyers, management lawyers, and employee participation from time to time. And I think we all should be cognizant of a Supreme Court decision that really, I think, should set the tone for this proceeding. It's NLRB versus Action Automotive. And there the Supreme Court clearly articulated that the board should remain, and I'm quoting, wholly neutral with respect to the representation process. I think that's exceedingly important for all of us to keep in mind. With that said, we would have hoped, when I say we, certainly the two parties I'm representing today, and perhaps others, would have hoped that this board would have reached a consensus as to the NPRM if you were going to proceed at all. This board has an extremely high intellect level, great experience, perhaps one of the most experienced boards in the history of the agency. And we are still hopeful that you could come to some consensus, all five of you, before proceeding, if you proceed at all. In the alternative, if that's not possible, perhaps you then proceed on negotiated rulemaking. Get the stakeholders involved. Let's have some dialogue beyond what we're having today. We're dealing with important issues that affect labor, affect management, and as noted, certainly affect employees. With that said, I want to spend a few minutes on the hearing officer issue. We really haven't devoted a lot of time to that. We obviously have a Section 9C problem from our perspective. There is a statutory requirement for an appropriate hearing in each and every case. A full opportunity for all parties to litigate as they deem appropriate, not delay, not stall, but to litigate and establish a record. And it's also incumbent under 9B of the Act that requires the board in each case, not the hearing officer in each case, not the regional director in each case, the board. And I certainly would identify with remarks that people in the field of this agency are excellent. They're trained professionals, no question. But ultimately, the accountability for issues that we're dealing with here today rests with the five of you, not with career civil servants. And that's where it should be. You're subject to Senate review and Senate confirmation. And many of us have great concern about pushing this down to the regional officer level. Finally, with respect to hearing officer determinations, I would gladly accept the federal rules of civil procedure, the genuine issue material fact. That question's been asked a couple of different times. That's an exceedingly difficult standard. Article III judges have a difficult time getting that right. Supervisory status, that issue in health care has gone twice to the United States Supreme Court. And still there's not great clarity. So to suggest these are just simple issues that can be easily dealt with by a hearing officer who may not even be a lawyer, I think is not practical beyond the legal obstacles that I've mentioned. So that's something that has to be thought about. A hearing officer is going to be placed in an exceedingly difficult position, making rulings. Yes, they can go to the front office, they can seek guidance, but not on each and every issue. And if they don't permit briefs, we haven't really talked about that. I know that will be discussed later. That's an exceedingly difficult standard. Due process violations? Absolutely. There's going to be a lot more litigation here, and we don't need to do it. What the board is doing today, day in and day out, and holding elections in this country, really is an example for the rest of the free world in many respects. What you do here, you do well. We don't need to change what we're doing today.
Questions?
Did I get to answer the question posed by Member Miscamara?
I asked the question.
It's not, as noted by my colleague Doreen Davis, it's just not supervising managerial and confidential status. What about independent contractors? You talk about a difficult standard. We have various statutes that define who is and who is not an independent contractor, from the IRS to the NLRA and beyond. Not easy. How are we going to deal with that? What about students versus employees? A difficult question. So in the managerial status, you have a case, and we're not going to discuss it here, but that issue of managerial status is important to consider. So this is an area where thoughtful people should be able to articulate thoughtful ideas, thoughtful positions, and reach an agreement. I would submit to you one of the real problems here is not having a minimum number of days between filing a petition and election. That would solve a lot of this. Yes, there's maneuvering on both sides. We all know that. Good lawyers use procedures to their client's advantage. You could call it delay. I don't agree with that. My union colleagues take every advantage of the blocking charge procedure. That's their right at this point. So let's talk about what really the issue is here. Is it jockeying back and forth on procedure rules? Should we have a minimum number of days between filing the petition and the election? Perhaps so. That might solve a lot of this. But back to your question, I think those are significant issues. And to put them off after the election, as been articulated by Mr. Pearl and others, is simply going to result in more litigation.
One follow-up to that, though, I mean, in your experience for independent contractor and sort of student as employee issues, isn't that something that applies to almost the entire bargaining unit? It's not a situation where you'll have like 2 or 3 people typically.
Yes, Member Johnson, I agree. I want to talk in the next panel about the problems with the board challenge procedure process, but yeah, that could affect a very significant number of potential voters. So I don't think we've really paid enough attention to that issue. And if you have 30, 20, 25% of the unit being uncertain on the independent contractor issue, that's a very significant issue that deserves attention pre-election, not post-election.
What would your minimum time be?
I knew you were going to ask that question.
I didn't want to disappoint.
And your maximum.
I don't have a minimum per se. I think what the board is doing today is appropriate. We have the 38 to 42 target that's being met consistently. And I think, to further answer your question, it depends on the size of the unit, the number of issues that are involved in the unit hearing. But if I were pressed, I think the legislation currently pending in Congress is a guide you might want to look at.
Thank you.